Good morning. Thanks for joining us today for our webinar entitled 2023 New Employment Laws, What Employers Need to Know. I'm Denise Keddy, and I'm the moderator for this session. A couple of quick housekeeping notes before I introduce today's expert panel. The webinar will run probably a little bit longer than our normal 60 minutes to allow for additional questions. Don't worry if you have to leave the webinar before the conclusion. A link to the webinar will be sent out and also posted on the Ethos YouTube channel after the webinar has been completed. Please take a moment now to visit the handout area on your dashboard to download a copy of today's handouts. Hey, Linda, I don't see anything advancing. Oh, there it is. Okay, thanks.
Okay.
I'm sorry, I did, my computer's a beat off. Sorry, my computer's one beat off. Sorry about that, everyone. Okay, so please take a moment now to visit the handout areas on your dashboard to download a copy of today's two handouts. Click View on your menu bar and make sure there is a check mark next to the sections for the handout and questions. If you have questions during the presentation, please post them in the Q&A area on the dashboard anytime during the presentation. If you would like your question directed to a specific panelist, you can note that when sending in your question. If you have any issues during the presentation, just drop a note in the question area. I'll be monitoring it as the presentations are going on. Just a quick reminder about today's webinar. It is being recorded and all accompanying materials are protected by copyright. Our presentation today is intended for information purposes only and should not be relied on or to reach a conclusion in any area of law. The information is offered during this webinar is as of today, December 1st, 2022. As always, we recommend that you consult your own legal counsel to address any specific situation and that you have the most current information on all legal matters. Let's get started in our session today. Each new year brings, of course, a new slate of new labor laws that will impact your business, and today is no different. So our legal expert today is Kurtis Urien. Kurtis is an associate at the law firm of Merhab Robinson and Clarkson in the firm's transactional department, where he advises clients in real estate, finance, and employment law. In addition to the work at the firm, Kurtis has contributed articles into law journals and lectures at the Business and Political Science departments of the American Jewish University in Los Angeles. Kurtis has also been recognized as a rising star by superlawyers.com for the last 6 years, so from 2017 through this year. Congratulations, Kurtis, for another outstanding year. Our human capital expert is Linda Duffy, founder and president of Ethos Human Capital Solutions. Linda is known as the people problem solver, and Linda and her team are known for building the magic of the human connection with their consulting, recruiting, training, and organizational development programs. Linda and the Ethos team work with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so that you as a business owner can focus on running your business and achieving your goals. Her clients range from high-tech businesses to manufacturing firms to nonprofit organizations, and she is extremely well-versed in the areas of founder, CEO-led businesses. Linda, do you mind getting us started this morning?
I do not mind that at all. Thanks, Denise. And thanks as always. Oh, it looks like I forgot to change it on this. So sorry about that. I hope I have the right presentation going. So let's get started. My agenda is pretty simple. New laws for this year. We're going to talk about a couple of great programs for employers and then also what the future holds, because we have a couple of laws that have already been signed, but they won't go into effect until next year. The other thing before we start talking about pay transparency, which is the first law we're going to speak about, is I want to make sure that those of you on here that usually like to get credits through HRCI or through SHRM for recertification, we did not apply this time, but you should know that you can still go out, you can still put in the information directly to say that you attended today and just provide all that information. It doesn't need to be pre-approved through one of those organizations. So Kurtis, let's get started by talking about pay transparency. There's 3 different parts to this, and I know a lot of our clients are really small, so they need to know that the first 2 apply to them. The first one being that this law makes it so any employee can basically come and say, hey, I want to know what the pay scale is for my position, right?
Yeah, that is correct. So there's three thresholds with the new pay transparency law. One threshold applies to all employers regardless of size. Another threshold that applies to um, slightly bigger employees or slightly bigger employers than your tiny employers. That's 15 or more employees. And then for larger employers, it's 100 plus employees.
And what are the differences? Let's go through each of those. So this first part is the pay disclosure also has to be put into job postings, right? So when they talk about the
Correct.
pay scale, they're talking about the salary or hourly wage that you reasonably expect to pay for the position. The interesting thing about this is if you're posting it through a third party, think you're posting on LinkedIn, you're using a recruiting service, you're putting it out on ZipRecruiter or Indeed, wherever you're posting jobs, you must put in the pay scale in those postings as well. Similarly, if you're posting it internally through a job posting system, you're going to have to include it in that. This is already in place in other locations like Colorado, New York City, and Washington, and there are penalties if you don't do it.
Yeah, the penalties can be small, $100, or they could be substantial, up to $10,000 per violation. So this is probably the of all of the new laws going into effect on January 1st, 2023. This is the law that is most likely going to require the most compliance work, and we strongly recommend putting time and effort into complying with this new law because there could be substantial violations with this new law. And the California Labor Commission or Civil Rights Division, whatever they decide to call themselves this year,
right,
is going to be enforcing these, because it's very easy to just go onto Indeed or Monster or Jobs.com and see what postings are being put out by the thousands of employers in California, and it's going to be very easy to determine if an employer is complying with this law. The salary range is either going to be on the job posting or it's not, and it's going to be very easy for the state to find violations and prosecute violators.
Yeah, now this particular posting requirement's only for employers with 15 or more employees. So, the department will have to do a little bit of research to determine it, but there's attorneys out there that are going to be all over this, right? Because it's an easy one, like Kurtis mentioned, easy one to look at. And keep in mind also, I should have mentioned this on the prior slide, we already have laws on the books that prohibit employers from asking candidates about their wage history, so just keep that in mind. But now you've got the flip side where the candidates and also current employees can ask about the pay scale for any job that's posted. So you're going to want to make sure that people can have that conversation and are trained to have that conversation. This slide is from Fisher and Phillips, and Kurtis and I both like some of the work that they do on this issue. So if you take a look at this and you go to that URL, you will see, and I just realized, Kurtis, I do not have the correct slides up here, so we're going to have to wing this one a little bit, but because we made a couple of changes last night. Yeah, so on this one, there is on the bottom of this one, there should be a little legend just to tell you that the gray states, I believe, were the ones that have gender specific requirements in place, and the red ones I think had gender and other protected categories that are covered by some pay equity laws. And then there's a couple of states that are, I think, Mississippi and North Carolina, that don't have any such laws in place. But just go to this. It'll really help you, especially if you have other employees in other states in the union. You'll be able to take a look at this map, and it'll help you know if you need to research a little bit further.
Yeah, the state is trying. Sorry, I just want to say this: the state is trying very hard to eliminate pay disparities between members of different sexes or different protected classes, and so the official policy reason of enacting this law is to provide employers with the tools to make it easier for employers to comply with the pay discrepancy, the laws against pay discrepancy among genders and other protected classes. A consequence of this law is that there's going to be a lot of lawsuits because there's a lot more strict compliance, a lot more requirements that employers are going to need to engage in and comply with, and many employers are going to miss it. And so there's going to be a lot of lawsuits. So the lawsuits too will, or at least should, have an effect of pushing employers in the right direction of eliminating pay discrepancies. But that's really what the state's trying to accomplish here, is trying to accomplish that equality among the private sector.
Right. So let's take a look at the third level of requirements under the Pay Transparency Act. And this is for employers that have 100 or more employees. So right now, if you're filing your EEO-1 report, you're already doing some pay data reporting. This is separate. This is above and beyond what you're already required to do for the EEO-1. I don't know how they arrived at this, but you need to report the second Wednesday of May each year. So the first time you'll have this requirement is the second Wednesday of May 2023, but you're using data that is for a snapshot pay period in Q4 of this year. So you're going to want to make sure that you're collecting the data now, or you have the ability to go back and run a report for a time period now so that you can report it next May. And the other thing to know about this portion is you have to include staffing agency employees' information. So if you have temps on site, you must report their info as well. So if you have temps, I would reach out to your staffing agencies right now. You need to be able to report what the employee is getting paid, which you may not know because your bills are going to show what you're paying the agency, which would include that markup. So just keep that in mind and make sure that you're collecting that information right now. So here are a few FAQs that we've been asked or have come up in other ways. What if multiple states have different ranges? Okay, you can decide what you want to do about this. You can standardize across the board in your job postings. Let's say you have an opening that, the person could work remotely. It doesn't matter where they're located. Maybe you pay the same amount. Maybe you say, you know what, it depends on the geography they're in. We're not going to pay somebody in Oklahoma the same we're going to pay somebody in San Francisco. You can note different ranges. You can make it specific to a location, however you want to do it. So it doesn't have to be the same range across the board. Kurtis, does the pay scale need to include incentive comp, bonuses, things like that?
It doesn't. The transparency laws are only requiring reporting or disclosure of the base salary or hourly range. But as we note here, if there's going to be an incentive pool or if there's going to be commissions, then we recommend posting that, at least general information about that as well, just so prospective employees have an idea of what they're getting into.
Yeah, exactly. Well, we all know right now it's so difficult to attract talent. So I would include whatever you need to, in addition to the base wage, just to be competitive in the marketplace. Because now that all the rates are going to be out there for everybody, except for super small employers, it's going to be really easy for candidates just to shop based on the compensation paid. If you have positions, and we don't have very many of these, Kurtis, I don't know if you do or not, that somebody's being paid piece rate or commission only, just convert it over to a range. You'll know, generally speaking, what people are being paid. So you can go through the effort of establishing pay ranges, like do market surveys, things like that, if you want to. You can also just report, like, let's say, for a position you pay right now, you look at your payroll records and you say, you know what, everybody that's assembler, 1 makes somewhere between, $16 and $21 an hour. That can be your range. Now, what you need to think about though is if that person that's making 16 comes to you and you report that range of 16 to 21, they're going to have a lot of questions, right, about why they're on the low end of the range. So, think about how you want to do this. If you want to go out and do market surveys, if you just want to report it based on what you're paying right now, because that would be what you would reasonably expect to pay somebody in the future. You can you can come up with your ranges a variety of different ways. And we are going to do another webinar that's specific to the Pay Transparency Act in January. So just know that we'll help you in greater detail at that point. And then the last question is just, what if we end up paying someone more or less in the range that we post? And the answer to that is it's not a problem unless it continues, because then it's going to be creating a new range for yourself. So Kurtis, here are some action items that we've recommended. You want to talk about the first couple?
Yeah, so the first thing you're going to want to do is decide which threshold, which range of this transparency law your company falls into. Do you have a handful of employees? Do you have 15 or more? Do you have 100 or more? And then once you've identified which level of the law that applies to you, then you're going to need to go and have training sessions with your supervisors, managers, HRs, recruiters on how to handle inquiries. Because employees are now going to know that they can come and ask for the pay range for the position, and your supervisors and managers and HR employees are going to need to know how to respond and how to work with questions like that. So, as I mentioned before, there's a lot of compliance work that's going to have to happen with this new law, and after you've figured out what your compliance looks like, then you're going to have to go through and start training your employees and get them ready for fielding questions like this. Because the last thing you want to have happen is an employee comes to a supervisor and asks for the pay range, the pay scale, and the supervisor not know anything about it and not having information on it. Then the employee is likely going to be suspicious and is likely going to want to talk to the state to see if they have a potential claim for pay discrepancy.
Yeah, and this is a good opportunity for us to remind everybody that there is a prohibition in the labor code that, a lot of times managers aren't aware of. Like business owners, managers, we talk all the time to them and they say, well, I told so-and-so to stop talking about their wages, or so-and-so is causing problems because, they're out there asking others what they make. You cannot prohibit an employee from disclosing his or her wages. So you want to make sure that your managers understand that, and that you're not going to get in trouble because they're out there when somebody asks for the pay range saying, you can't talk about wages. I already mentioned
and it's also, sorry, I just want to interrupt. It's also a violation of federal law too, under the National Labor Relations Act. Employees are free to discuss their wages and working conditions as a concerted activity.
Right. Thank you. I already mentioned making sure that you contact any temp agencies right now for whatever pay period you're going to report next year to get that information. Look in your handbook, make sure there's nothing in that handbook that prevents employees from discussing wages. I know when we write handbooks, and we write a lot of them, we always say anytime we talk about employee privacy or anything like that, we always have a disclaimer that says there's nothing in this that prevents employees from discussing their wages or working conditions. And then the final recommendation is, get in contact with us, do a pay equity audit now to make sure that you're not going to have an issue next year when you start reporting these wages. We can come in, we can help you make sure you have people classified properly. We can do market surveys for you. We can do whatever we can to help you make sure that you're in compliance now and you're ready next year. Okay, moving on to bereavement leave. This is a new one under AB 1949, also takes effect January 1st. So in this one, the states never had a requirement before that employers offer bereavement leave. This is unpaid, generally speaking, but you must allow employees to take up to 5 days of bereavement leave in the event of a family member's death. And there is the definition below about who a family member is. So there's certain rules around it. They have to take it within 3 months, but they do not have to take the days consecutively. So someone could come to you and say, grandma died yesterday, I want to take the next 2 days off. Then they can come back and say, 2 months later, hey, I want to take the other 3 days. That's perfectly acceptable. If you have a bereavement leave policy already in place that does offer pay, you must continue to offer that pay. But let's say your policy says, we pay 3 days for bereavement leave, which is fairly common. This says 5 days. You do not have to change it to say we're going to pay those 5 days. You would allow them to be paid for the 3, and then you must allow them to take the other 2 unpaid or let them use any accrued time off, either way. So this is something that definitely has to be updated in your handbook going forward. Kurtis, anything you want to add to that?
Just to echo your last statement, this is an update to the employee handbook. This is an update to your procedures. Make sure supervisors and managers know that employees do have this right. So if anybody ever calls in, says, I need to call in sick, grandma just died, they need to think, no, this isn't sick leave, this is going to be bereavement leave. And they need to make sure that they're following this new procedure that all employers are going to have to adopt if they haven't adopted one already.
Great. Good time always to remind everybody minimum wage is going up January 1st. This is now the tail end of what's been going on for the last 4 or 5 years, where remember employers under a certain head count and over a certain head count had different minimum wages. Well, now everyone's going to be on the same plan as far as the state's concerned. So this is a state minimum wage for all employers will be $15.50 per hour. Certain cities and counties may have a higher premium or higher minimum, I mean. If you look in the handout section that's on that menu Denise pointed out before, you'll see that we did upload a list of the cities in California that have different rates. So make sure you download that, see if you have any employees that work in those areas. Also, when minimum wage goes up, remember that the minimum salary for exemption goes up. So starting in January, that minimum exemption, $64,480. This is just the white collar exemptions. There are additional higher level pay for doctors, for IT professionals, people like that. So there are a few exceptions, but just know that you always want to take a look at your employees' minimum salaries and make sure that you're compliant there. So what are some good action items for them on this, Kurtis?
So really 2 main action items. Make sure that all of your employees who are at minimum wage do get this increase for January 1st. And then second, to make sure that any employee who's receiving the salary is receiving at least the minimum salary. When the state goes to do an audit, or if an employee is looking to see if there's any claims, or if we go in and we do pay audits, the first thing we look for is for employees who are paid on salary who are being paid less than the minimum salary, because that's an easy violation to find.
Super easy, right?
And also, yes, yeah. I mean, it's the one we don't even have to think about.
Right.
And know going forward that the last 5 or 6 years we had the incremental yearly increase that was based on a law that the state legislature passed. But in the future going forward, the annual increases in minimum wage are going to be based on inflation. So this last year we've had a high amount of inflation, so that's why we're automatically going to get this increase here on January 1st. But if we go through 2023 and there's very little or no inflation, then there might not be an increase for 2024. So each year as we go forward, the minimum wage is going to be tied to inflation here in California.
Exactly. Okay, another law that's changing is the California Family Rights Act. So this is actually an expansion. I shouldn't say it's a change, but it's an expansion. And the expansion, and this also affects sick pay, is now on your list of family members for whom an employee can take leave, they've added this designated person. And that means anybody that's related by blood, and this is the key phrase, or whose association with the employee is the equivalent of a family relationship. Kurtis, what in the heck does that mean?
That's a great question.
I set you up on that one.
And, well, there really isn't an answer. I mean, I get that the legislature is trying to give more rights to people, to say maybe you have a best friend that you've known for your whole life, you're very close with, and that person gets sick, and you're the closest friend or closest person who may be able to care for that person. The law is now going to give you the ability to take time off, protect the time off to care for that person.
Right.
Some people say that your friends are the family that you choose. And so I get what the state's trying to do, but the specific law is so broad that you can designate anybody you want to, really.
Pretty much, right? My neighbor, she's been like a mother to me. My best friend's like a sister to me. Like I can see it be a really slippery slope. So, you know, this is going to be tough because it's going to open up the opportunity for people to take a lot more time off. But proceed with caution, right? If somebody comes to you and they want to designate a person, they do not have to do it at the time of hire or at the beginning of the year, anything like that. They can just walk up to you, just like they could right now, trying to take any, CFRA leave to care for somebody else and say, I want to take leave to care for this person, and it's my fill in the blank, neighbor, best friend, whoever it is. And, reach out to us, reach out to counsel. We can help you sort of digest this, but I think that this is one of those, Kurtis, correct me if I'm wrong, that's going to be decided in the courts at some point.
Yeah, whenever it's vague or ambiguous like this, we almost always have to rely on court interpretation.
Yeah. We put this slide in just to remind everybody a couple things about the Form I-9. So those of you that are used to onboarding employees, you'll know that the form expired 10/31/22. That's a screenshot at the bottom. You need to continue using this form until they produce a new one, which right now we don't know when that's going to be. They're giving it a makeover like they do periodically. The good news about the Form I-9 is you can continue to inspect the responsive documents virtually as long as those employees don't report into to a physical location. So if, like, we're based in California, let's say I hire a consultant that's in Nevada, we don't have a physical location there, that person's not required to come to California. I can, I can inspect those documents on a Zoom call, have them hold them up, or other ways to do it, right? So, but it's only for that. If they come into the office on a regular basis or then you have to inspect them, in person like you used to have to pre-COVID. So just something to know that. Once the new form is released, just remember you are not required to go back and have everybody fill out that form. We've had clients do that before where it's a new form. They think everyone needs to sign it up again. You're actually prohibited by law from requiring that. So don't do it, just use it going forward. Kurtis, the next couple, we don't have a lot of clients that play in this space, so I'm just going to go through these real quickly. The first one is there was a council, the fast food council that was established. So there is a definition of employers that fall under this particular law. Just know that this 10-member fast food council is going to be able to determine standards for the fast food industry, including like minimum wage. They could come in and say, you know what, state says it's $15.50. We think for fast food workers it's going to be $20. And I don't know that you're going to have a lot to do about that. Anyway, there's more to it, but again, we're just going to go through this real quickly because we don't have a lot of clients in this space. Similarly, there's LA hotel worker protection. So this one, Kurtis, is a little bit more detailed because it has to do with safety, and it also has to do with productivity and paying people according to how much work they're doing, essentially. What can you tell us about this one?
This is an interesting law. So I tend to be a proponent of free market enterprise, but it's hard not to recognize the abuses that do happen in the hotel industry with hotel workers and the individuals who go through and clean and provide room service. So the goal here is to provide more safety and more security to hotel employees. And each employee has to be provided with a security device like a life alert button at no cost to the employee, that the employee can hit if there's ever any kind of threat or any kind of harm, or if there's any kind of improper situation. And there's also going to be limits on how many hours per day an employee can work. So it's interesting to see where this will go and what the effects of this law, and if it actually will provide safety and security to hotel workers.
Right. There are some notice and posting requirements, and this does apply to hotel employers in the city of Los Angeles, not the county, but the city. And then there's also something for hotel employers. We just want to make sure that if you are a hotel employer, that there is this new bill that says that you have liability if you're not complying with some of the human trafficking laws. So if a supervisory or managerial employee of yours sort of, you know, they say acted with reckless disregard of that activity and you're caught, then you're going to have some penalties attached to that. This one, Kurtis, the Fair Work Ordinance, again, is going to apply to the city of Los Angeles, and it applies to national retailers with 300 or more employees globally. So you could have 5 employees in the city of Los Angeles, but if you have 300 or more employees across the world, actually, it's going to affect these employees. And so this one basically is mirroring what San Francisco did a few years ago, I believe, which is wanting employees to have their schedule at least 14 days in advance, so they can make sure that they, you know, have a more predictable schedule. What should we know about this one?
Yeah, I don't think we have too many clients that will be affected by this law, but I think it is interesting that that LA is trying to provide this more predictability of pay, guaranteeing minimum number of hours a week, guaranteeing that employees can have their schedule at least 2 weeks in advance. Because I think a lot of employees who work in this category are working more than one job, so I think it's designed to help them have that flexibility and ability to schedule their lives accordingly. So it's interesting. I don't think there's many action items that we have on this one, but it will be interesting to see where this one goes and what happens with it.
Absolutely. And it does say, I have some notes on this, it says that if you have an NAICS code of 44 through 45 within the retail trade category, that's a subcategory 44 through 45, this is going to cover you. So just know there's a lot more detail to this law, so you're going to want to check into it. It does not go into effect until April, so you still have 4 or 5 months to get caught up on this. All right, Kurtis, this is a big one that we're going to need help with, right? So this is going to be, for some employers, a really big one. So it's effective in January. They say they're not going to enforce it until July. This is actually an expansion of what voters passed a couple of years ago regarding privacy rights. And then now this is the portion that applies to employers and employees' rights. So it's part of the same sort of umbrella law. This applies to for-profit businesses that do business in California, and then you are subject to this law if you meet one of these 3 criteria here. So if your gross revenue for the preceding year exceeded 25 million, or you buy, sell, or share personal info of 100,000 or more consumers or households, or you derive 50% or more of your revenue from that. So this only applies to employees who are California residents. So even if you're here, it does not affect employees necessarily that are in Oklahoma or someplace. But this one is going to have some really specific requirements, starting with what's considered personal information. Kurtis.
Yeah, so this is an interesting law, and the history behind this law is also somewhat interesting and somewhat entertaining, depending on your perspective. But some listeners may remember back in 2018 or so, the federal government reversed its regulations on net neutrality. And so some California residents decided that California was going to adopt its own version of rules for the internet and for collecting their personal information. And a proposition was proposed to California voters, but the state didn't like this handful of the people were going to write this new law. So the state had an agreement with these individuals who were creating this proposition that the state would create a Consumer Privacy Act, which the state did and passed. Then these individuals were not happy with what the state created, so the individuals went ahead and created their own proposition and put it on the ballot of CPRA, which, as Linda said, amended and expanded some areas of the California Consumer Privacy Act and narrowed some areas of the California Consumer Privacy Act. Now, initially, employers were not really considered to be a target of the CCPA, but due to the wording of CCPA, employers are included in compliance with CCPA for-profit employers because employers do collect private information from employees. And initially, the state didn't realize that this was going to be a consequence. So once employer groups like Cal Chamber started complaining about the new law, the state pushed back the first date of compliance for employers with CCPA, because under the terms of the code section, employers should have already been complying with this law, but because of different questions and the burdens and understanding what was going to have to be done with this law, compliance was pushed back to January 1st, 2023. And their employers are going to get a buffer the first 6 months of 2023 to figure out compliance. The state's not going to start enforcing until July of 2023.
Yeah.
The biggest thing to note here, go ahead, sorry.
No, go ahead.
The biggest thing to note here is this only applies to certain employers. It's not a broad spectrum of all employers. This law only applies to for-profit employers who have the business has 25 million or more in gross receipts, or receives 100,000 or information on 100,000 more people, or is in the business of collecting and selling consumer information. If your business does not fall into one of those categories, then you don't have to worry about compliance with this law. However, if your business does fall into one of these categories, you must absolutely be concerned with compliance with this law.
Yeah, and there's certain things that you have to do, Kurtis. I just wanted to point out, so this information that you see on the screen right here, this personal information, obviously it gives rise to, you know, some potential financial harm, you know, or a data breach, you know, if your social security number gets out there, or, you know, your passport or whatever it is, you know, it could make you more, you know, susceptible to identity theft, things like that. So that's part of why they're doing this. There is going to be a disclosure that's required that you give your employees that tells them the categories of sensitive information that you are collecting, as well as your reason for collecting it. And so we're going to have, you know, you're going to have to be developing these disclosures if you are, you know, under one of those categories that make you, you know, need to comply with this law.
Yeah, my office is working with clients who are subject to this law, and we are helping prepare the notices and the different policies that must be included. Like you said, the initial notice must actually go out to prospective applicants when they apply for a position, because that application does contain information on that long list of personal information that's subject to the law.
Yeah, hopefully not your social security number. So there are some new obligations and new employee rights that are created under this law. I'm not gonna go through all of these, but you'll notice a couple of them, like the right to opt out and the right to delete some of the personal information. Now, just know this, just because that's a right under this law, if you have a business reason that makes a necessity for you to keep some personal information, the employee can't overrule you and say, no, delete my social security number when you have a requirement to pay taxes using that social security number, right? So one of the things Kurtis and I were talking about yesterday as we were reviewing this is let's take a look at your Form I-9s, right? So they give you responsive documents. Maybe they provide a passport. Maybe they give you a driver's license and a social security card. Well, up until now, you've always maybe had the practice of keeping a copy of those documents with your I-9 forms. Is it a necessity to keep those documents? I would argue no, it's not.
Probably not.
Probably not. So if an employee came to you and say, hey, I want you to delete that piece of paper where, you know, you've copied my documents, I think as of right now, my recommendation would be then delete it. You know, make a note that it was done at the employee's request if your intention is to continue to maintain copies of those documents. And again, you're going to have to disclose to people, this is what we do. we take copies of them, we attach it to the I-9, we put it in this binder, you know, here's who has access to it, those type of things, or change your policy and stop taking those documents, right? There's different ways to do it. So there's a few action items, Kurtis. So let's talk about this. You know, first, obviously, like you mentioned, apply whether, you know, figure out if the law even applies to your business. And then you were mentioning developing the necessary disclosures.
Yeah, after you've determined if the law applies to your business, then you'll need to prepare the notices and disclosures that go out to employees, and then have separate policies that discuss how the employer handles personal information and what the purposes are for holding that information and what the company will do in different situations. And then you're going to need to go through and train your managers and supervisors that they're aware of of employees' rights to make requests to delete certain information or to opt out of having to provide certain types of information.
Yeah, I'm sure we will be talking about this in much greater detail on a future webinar. But right now, just know this is going to be a big change for some larger employers or employers that play in, you know, in a certain industry. So just make sure if it applies to you that you get with Kurtis or with us or somebody that can help you through this process. Here's another employee privacy law that goes into effect January 1st. This one's specific to monitoring vehicles. It's actually going to be a section of the vehicle code, but employees can file a claim with the labor commissioner. And this has to do with monitoring like GPS location. So it's specific to fleet and commercial vehicles. If you do have some sort of tracking device on those vehicles, and you allow the employees to, you know, drive the vehicle in non-working hours, they must be able to disable the tracking device itself. And it also has a notice requirement. Anything else, Kurtis, that we need to know about this one?
Yeah, this is a curious law because there's already provision in the criminal code that says that one person cannot use GPS tracking to track the body or person of someone else. So my firm, we work with a good number of distribution and warehousing clients. We have a lot of clients with employees that are outside sales or outside marketing. So we deal with this a lot. So there's specific notices and specific disclaimers that need to be made for employees who are being tracked, whether it's a company vehicle that has a device attached to the vehicle, or it's an application on the employee's phone that tracks where the employee is going, or it's a company iPad that the employee or other device that the employee has to keep on their person while they're working. So the law does have some specific details that we don't really have time to go into during this webinar, but do know if you are tracking company vehicles or employees while they're out working, be sure to have a conversation with us so we can walk you through the requirements and what the do's and don'ts.
All right, great. So some of you may remember the Fair Chance Act that went into effect a few years ago, also known as Ban the Box. This has to do with asking on a job application for any sort of conviction history before you've made an offer of employment. So hopefully you're not doing that. The only reason we included this slide is because the Department of Fair Employment and Housing, which is now called the California Civil Rights Department, in case you missed that memo like we did back in the summer, because they just sort of changed their name without telling you. They've announced a new effort to sort of enforce this law. So this has to do with all California-based applicants and employees, regardless of where it's headquartered. So I assume all of you on this call today are based here in California, but if you're based someplace else and you're here because you have California employees, just make sure your application forms aren't asking this question and that you're not doing any sort of background check until a conditional offer of employment's been made. All right, hate crimes. This was an interesting one. So I was telling Kurtis that I know when we do harassment prevention training for managers, we're talking about different protected categories. And you know, I'm always surprised of what is included and what's not included in different laws. In this case, this is sort of an expansion of something that was already in existence, but it's increased the penalties for offenses relating to hate crimes. And specifically, it says displaying something like a swastika, a noose, a burning cross, something that's tied in those examples to like race or ethnic origin or something like that. So a lot of times, you know, employees don't understand that this could be a problem. I'm shocked to sort of say in 2022, but even as a joke, please make sure that you're enforcing this policy and you're not letting people display any kind of signs or marks like that around the workplace.
Yeah, and make sure when you do your anti-harassment training, anti-discrimination training, that this is discussed and that employees know that they should not be engaging in misconduct.
Exactly. All right, good old meal rest period penalties, Kurtis. There's a few laws and a few case laws that went into effect this past year.
Yeah, I really don't like this case. I say that tongue in cheek, but I actually expected the California Supreme Court to eventually change the law and go this direction. So it used to be that a meal and rest break premium was more of a penalty, more of a slap on the wrist for not following the law. But the Supreme Court decided to change that. Rest and meal break premiums are now considered wages, which may not be settled or released and must be paid. And because they're wages, they must be paid at the regular rate of pay, that weighted average of all earnings during a work week or a pay period, divided by the total hours of the employee, the total hours worked. And the premiums must be included on wage statements. So there's another item of compliance on wage statements. So I kind of expected this to happen. I had hoped that it wouldn't, but this is a substantial change that employers are going to need to be aware of and are going to need to comply with whenever an employee incurs a meal or rest break premium.
And let me just add something else to this is I know like the payroll company that we use for our own payroll, they didn't automatically switch this when this case was decided. It drives me a little crazy, but a lot of times you have to take the lead with your payroll provider to say to them, hey, this law, you know, has been decided. We need to make sure that these premiums are getting paid at the regular rate of pay. And again, if you don't know what that means, call one of us. But you need to make sure that they're doing it correctly. They might be waiting for you to authorize them to make a change like they were in my case, but you want to make sure that it is being paid correctly and that it is being paid, is showing up as a line item on your wage statements or pay stubs for your employees, right? Because if not, that's going to be a big PAGA claim coming your way. So we want to make sure that that doesn't happen. The other thing is when that decision came into effect, or actually it was the FARA decision, I believe, said that this is applied retroactively. So you have to decide for yourself, do you want to go back and look to see how these were paid over the last 4 years, because they would not have been paid accurately, most likely, since this wasn't decided until this year. I don't know, Kurtis, how courts can say make it retroactive when you didn't know that it was even a requirement. That is a little crazy.
Blows my mind.
Yep. All right, so let's talk about arbitration. So Kurtis and I differ a little bit on this topic. So we're going to play point counterpoint on this, but I think we can agree on the pros and cons of arbitration. Kurtis.
Yeah, we agree on the pros and cons of arbitration, and we also agree that all employers should have arbitration agreements for all employees. We generally believe that the pros outweigh the cons, that arbitration is faster, simpler, it's less expensive. You have more flexibility. It's a private proceeding. So any court action or any action with the California Civil Rights Department, or whatever they call themselves now, that's all public. Any employee can go on and see what's happening on somebody else's lawsuit against you. Arbitration is not the case. Arbitration is private. And you actually have an arbitrator who is familiar with the subject and is an expert on employment law and is more likely to grant an award that's accurate to what the employee is entitled to, instead of some ridiculous award that 12 licensed drivers think is appropriate. There are some cons. Arbitration is you have to pay for the arbitrator's fees 100%, and there are limits on discovery and pretrial motions, because the arbitrator has discretion to do kind of whatever the arbitrator wants, subject to the arbitration rules that you agree on. But generally, we think that the pros of arbitration in the employment context outweigh the cons, and that every employer should have an arbitration agreement.
Yeah, so the good news is, I guess, for employers, and why we included this is because right now there's like sort of, I guess the laws around this are undecided, or, they've flip-flopped so many times over the last couple of years, Kurtis, you get a little whiplash trying to keep up with arbitration agreements, right? So without going into all of this, just know that right now the law, there was a law that said, oh, you can't make them mandatory, you can't do certain things, you can't include PAGA claims, you can't do all of this. That law right now, the court withdrew its opinion on this, and so that law is currently unenforceable, which gives us a little bit of a window if you as an employer decide that you want to make arbitration agreements mandatory. So the first thing you need to do is decide whether you want to use arbitration at all. Some employers may decide they don't want to do it. Then you got to decide whether you want to take a conservative or aggressive approach. So Kurtis, you want to take the conservative one on this, and I'll be more aggressive?
Yeah, so my office, and many of you know Merhab Robinson, we agree on this, that employers should take the conservative approach, presenting arbitration agreements to employees, slip it into the packet of documents that they're going to sign when they begin employment, but don't make it mandatory. And like Linda said, there's a law of California that said you can't make it mandatory, but it's being challenged. We don't really know where we're at on that challenge. But just from a general legal contract perspective as well, all contracts to be enforceable must have mutual assent, meaning both parties must have voluntarily agreed to enter into that contract. So if there's any kind of force or duress on one party, the court's going to invalidate that contract. So we just generally don't think that an arbitration agreement should be mandatory. We recommend that employers give employees the opportunity to not enter into that or not sign that arbitration agreement.
So there's another attorney that we work with sometimes who takes a more aggressive approach. So, he has successfully defended his arbitration agreement that was made mandatory. So there's a whole package you roll out to the employees, whether it's now or upon, hire, and it basically says, hey, this is how we resolve disputes at our company. We use arbitration. If the employee does not want to sign it, we would agree with Kurtis, you don't fire the employee, you don't refuse to hire the employee, anything like that. You simply say, this is our policy, this is how we do things, and by accepting employment at our company, you agree to abide by our policies. So you would almost document it like you would a written warning or something that someone refuses to sign. Just document that they received it. Say they had an opportunity to sign and they refused to, that's fine. And then we're just going to move forward and assume that if something ever comes of it, and we need it, that it's going to be there. He says he successfully defended his arbitration agreement 3 times. So, what we do with our clients is we say, which way do you want to go? Essentially, do you want to be more conservative and have people, give people the opportunity to opt out, or be more aggressive and say, this is mandatory? The other couple things to know about this is there was, Kurtis, there was a national law, HR 4445, signed by Biden back in March, just saying that employees, you should explain this one, cannot have employees sign a pre-dispute arbitration agreement with regard to sexual harassment and sexual assault. You want to explain what that means?
Yeah, so this was a bipartisan bill too. both parties in Congress approved of this bill. So it says you cannot require arbitration for sexual harassment, sexual assault, discrimination, those types of claims, because the policy is there that employers should not be engaging in that conduct, and employers sometimes try to hide those cases in arbitration and try to make them private. So the idea is that by making those cases public, employers will be allowing that type of conduct less often. So just know when you have your arbitration agreement, make sure to put in an exception for cases of sexual harassment, sexual assault, discrimination, etc.
Great. And one last reminder, an agreement, like an arbitration agreement, we never include it in the handbook itself. We'll reference it, but we always advise that it be a standalone agreement that's signed separately from the handbook.
Yeah, arbitration agreements are narrowly construed by judges. So that means that when a judge gets an arbitration agreement, the judge is going to look for reasons to invalidate it. And there's a lot of reasons that judges have found over the years to invalidate arbitration agreements. So it's very important when adopting an arbitration agreement to work with counsel, someone who's been following and keeping track of the cases, so that your arbitration agreement can be as strong as possible. We can't guarantee ironclad, but we can get you as close as we can.
There you go. Hey, Kurtis, before we move on, those of you that are following along on the handout that we uploaded, you'll notice that we skipped a page because I uploaded the wrong PowerPoint today. My apologies. You want to talk briefly about Camp versus Home Depot?
Yeah, so we've talked about rounding practices, timekeeping policies before, and California courts are very slowly chipping away at employers' ability to round employee time clocks. So some employers have a practice where an employee clocks in at, say, 7:57, the employer will round that up to 8 o'clock. Well, there's actually no statutory or regulatory basis for rounding policies in California. There are under federal law, and many employers have relied on federal law for rounding practices, but the courts are catching on. And so the Home Depot case basically says that if an employer has the ability to have a time clock or a time tracking system that can measure to the minute, then the employer should not use a rounding policy. So it's not an outright ban on rounding policies, but I predict we're going to get there. So I've started recommending clients to not use rounding policies and to change and keep track of time to the minute.
Yeah, we make the same recommendation. Okay, workers' rights in emergencies. This is a new Senate bill, 1044, state Senate bill, goes into effect January. It basically says, hey, under certain conditions, you can't prohibit an employee from refusing to report to work or leaving work or using their cell phone at work. Again, the definition of emergency condition is very, very specific. It does not include a health pandemic. We do have, especially manufacturing and distribution clients, who like to have a policy to say cell phones can't be on the shop floor. You're perfectly fine to do that. Just know if there's this condition of disaster and so forth, that they're allowed to go get their cell phones. All right, workers' comp, AB 1751 goes into effect January, but all it does is just extend what the governor, I don't know, said is a rebuttable presumption. I don't even have a better word for this. Dictated, there you go, dictated that if an employee was, if an employee gets COVID-19 at work, then it's going to be, I'm not saying this very well, Kurtis, help me out here.
Yeah, so the executive order from the governor was that if anybody gets COVID, there's a presumption that person got COVID from work. And if you get COVID from work, then it's a workers' comp illness. And so the legislature, after the governor made that executive order, codified that. And this most recent version extends that rebuttable presumption through 2023.
Thank you. And along that line, we also know that AB 152 extends the supplemental paid sick leave through the end of this year. Cal OSHA, remember, had the emergency temporary standards that went into effect a while. Those also got extended. Everybody's more or less in alignment now, right? Because the ETS, the emergency temporary standards, does get revised periodically, so it's in line with California State, California Department of Public Health and the CDC, because for a while they weren't on the same page. So thankfully they are now. They have proposed a permanent standard. So we're waiting to hear on that. Hopefully, as I told Kurtis, they're usually late to the party, but we'll see what happens. Here's some good news though about your COVID-19 supplemental paid sick leave that you've been paying this year. The state has approved a grant relief program that would reimburse you up to $50,000 for that paid sick leave that you've been paying out. Now, there's rules around this. You have to be a corporation, you have to be a nonprofit, you had to begin operating before January 1st, yada, yada, yada. It's for if you have 26 to 49 employees, because you didn't have to pay it if you didn't fall into that category. And you have to be able to have a lot of supporting documentation through payroll records, like a line item that says this was, supplemental paid sick leave. I will tell you that I have looked. We do not see the website yet. There's supposed to be a portal where you can go in and apply, but you have all of next year to apply for it, so don't worry about that, but just make a note for yourself to come back and look for this, because if you did pay out SPSL last year, then you'll want to be able to collect that back. Another reminder, that time of year, always remember that you have to do harassment prevention training for your employees if you have 5 or more employees in your company. So that's 1 hour every 2 years for your employees and 2 hours every 2 years for your managers. You also have to do it within 6 months of hire or 6 months of promotion in the case of managers. So just make sure that you're up to speed on that. If you need help with that, we offer it as live training via webinar, and also we have an on-demand platform so people can complete it online at their own pace. Another program I like to share, and a lot of employers don't know about this, is the Employment Development Department in California has what's called a work share program. We have had a couple of employers recently prevent layoffs by entering this program. We have a mortgage employer, we have an escrow employer, and right now times are tough for them because of the interest rates. And so we were able to get them signed up. And how this program works in short, and again, I encourage you to go to that link or call us and we will talk you through it. You go onto a portal, you apply, you give information, and as long as you have 2 or more employees, you're eligible to participate if you're going to reduce anybody's earnings or hours by between 10% and 60% in a week. It doesn't have to be the same amount, but let's say right now everybody's working full time and you're thinking I might have to lay off some people, but instead if I cut everybody's hours or some people's hours by 20%, so they worked 4 days a week, what this program does is gives them a greater percentage of unemployment back. I'm not going to go into a lot of details about this, but if you do it this way, they'll be able to recover more lost wages than if they went out on their own to apply for unemployment for those lost wages. So just reach out to us if you have any problems, or go investigate this, because it's a great, great program. Okay, Kurtis, the other page that everybody has in their handout that, again, my slide is not here, are a couple of laws going into effect, not this January, but in January 2024. So while we talk about these 2 laws real quickly, because I'm watching our time also, it's a little bit after the hour, I'll just remind everybody, drop your questions into the question portal on the dashboard that you have, and then we'll get to those right after we talk about these 2. So the first one, Kurtis, is AB 2188 that goes into effect January of 2024. You want to talk about that one?
I'm not good at the bill numbers. Is this cannabis,
is a cannabis,
or?
Yeah, cannabis.
Okay,
sorry,
yeah.
Cannabis.
So starting January 1st, 2024, employers may not take a adverse employment action against an employee because the employee was recreationally using cannabis. So my recommendation, starting in a year from now is to, if an employer is going to be doing drug screens, to not even test for cannabis, because it's going to create more problems than you could be potentially solving.
Yeah, there are exceptions for certain industries, right? Or if they're doing work like in a federal location that, is going to have a different law. So some employers are going to have to continue to test, but what the state's requiring is that you do a really specific test that is more detailed, that can tell you more than just it's in your system. What they're trying to do is find impairment and not just usage, if that makes sense. So just know that this will be on the horizon for a year from now. The other one is SB 523, which is the Contraceptive Equity Act of 2022. So tell us about that.
Yeah, so this is going to, we already know that sex is a protected class, but this law is going to expand the definition of sex to decisions regarding reproductive decisions and decisions regarding reproductive health. So those would be protected decisions. An employer would not be able to have any adverse actions against an employee who makes decisions regarding their reproductive health or anything like that.
Okay, great. All right, Denise, I am going to turn it over to you for questions and answers. And I'm also going to put up our slide that shows the date of our next webinar, which is going to be on pay transparency. Kurtis and I are going to do that along with a guest speaker, Laura Conover, who's a compensation expert.
Great. Okay, everybody. So we have a lot of questions in certain areas, of course, and in the beginning, because we started with pay transparency, that's where our questions start. So for postings, does this include when we post a position on our own company portal where applicants can apply? So do they have to post the pay scale on an internal portal?
I believe they do. I know that if, and Kurtis, you tell me if you think, otherwise, right? But I know if there's an internal posting, like you have a job bid program or something like that, you would have to include that. You have to include it. They didn't do a good job defining job posting, right? So part of this is going to be, again, trial and error. I think you should just get in the habit of wherever you're posting it, you should just include it. When we do a retained search for a client, we don't necessarily post that job. So like what we don't know yet is when we put together what we call a success profile, do we have to include it in that if we're not posting it? I don't know, time will tell, right? But if it's something internal, I would just get in the habit of just including it.
Okay. So there was a breakdown that you guys went through for pay transparency on the size of the company. So one of the questions that came in was, we have one owner with two companies under them. If they add the two companies together, there would be over 100 employees. If the company stands alone, they would not equal 100 employees. Where do they stand on how they handle pay transparency?
I don't know off the top of my head the definition. Do you, Kurtis?
I apologize for giving every attorney's favorite answer, but it will depend on the specifics of the relationship with the companies, what kind of control is asserted. So that's a specific question that we need more information on to be able to give an answer. But it could potentially, the employees between the two organizations could possibly be aggregated to equal that 100.
Yeah, usually in the laws, and I just didn't look for that answer. So if whoever asked that question, I can, read through the law to see if there's a definition. Sometimes there is, sometimes there isn't.
Yeah, California has just general common law rules for employer aggregation. So, like I said, it just depends on analysis of those California common law decisions.
Okay, another question on pay transparency. Currently, the company that in question, they have a number of employees at a certain level. They're getting paid $16 to $21 per hour. Last year, someone left the company, but that person was paid $25 per hour. Is that going to matter in the pay transparency going forward? Do they have to claim or let people know that they were paid? Perfect.
No. So the rule is you have to reveal the pay scale that you would reasonably expect to pay somebody for that position. So, if you reasonably expect someone to pay somebody $20 an hour, you could use a pay scale of $20 an hour. We would recommend a range, but you could, in theory, under the law, say, we expect to pay someone $20 an hour for this position. Again, Kurtis and I were talking about this last night. I think if your range is $16 to $21 an hour, and you're going to bring some people in at 16, I might say it's $15.50 to $21.50 or something like that to give a little bit of wiggle room. But even if you ended up paying somebody $24 an hour or paying someone minimum wage, that's allowed. So you're not locked into the range that you post. It's just what you reasonably expect to pay. And then if you go outside of that range, you would document why. So maybe somebody has a lot more experience than you originally anticipated, right? Someone comes to you and they have a master's degree for whatever, that they're going to use. So if you look at it and you decide we need to pay more because temporarily market conditions are such that we require that, you can still do it. You're just like all equal pay laws, you're going to have to document the reason for the exception, but you don't have to include that in the pay range if you don't think that's what you're going to pay when you go into it.
Okay. Switching subjects to CPRA now. Does CPRA, easy for me to say, does that apply to nonprofit organizations also?
It does not.
It does not. It's only for-profit businesses.
Although Kurtis and I are talking about this, it's a slippery slope. We think it'll get there because that's the obvious one, right? They have a lot of information on donors. And so we suspect that it will get there, but it's not there right now.
Well, and sometimes a not-for-profit entity might own a for-profit entity, and that would be a different situation that would use a little bit of different analysis. But the general rule is nonprofits that right now are not required to comply.
Okay. And is there an easy list of required retention documents that a company can access?
Say that again.
For this new law, is there one list of required retention documents that someone could go online and say this is the required retention documents we need to have for that new law?
I don't know what retention documents means, Kurtis, do you?
No, I'm not quite sure I understand.
Yeah, I don't understand the question.
I mentioned before, I've worked with employers to provide the different forms and documents that are necessary to comply with the law. So feel free to reach out to me and more detailed question.
Okay.
Yeah, there's going to be different notices. So I just don't know what retention documents means. So.
Yeah. How does this work for employees that have government clearances? And requires documentation for this. How does this
CPR?
The CPRA? Yeah. Mm-hmm.
Again, I'm not sure what the question is. So how does the CPRA work
if the employers have employees that have government clearances?
I probably need to take a deeper look into that question and with some more specific details. We mentioned before that CCPA does have an exception for information that is necessary for the business. So that might be an exception that would apply in that situation, but I would need to have a separate discussion on that question.
Yeah, we would need a little bit more detail. So there are certain rights. I don't know if this is the slide that you're referring to in that question, but there's different rights like the right to opt out, the right to delete information, things like that. But as we mentioned, there's exceptions, right? An employee cannot say, I want you to delete my social security number because we need it to process payroll and pay them. So if you need to maintain information in order to comply with a different law, you're allowed to deny the request of deleting or opting out of information. So don't know if that helped or not. We're at 3:14. Do you have any other questions as we wrap up?
You know what? We'll do one more question that came in, but there are a lot of questions that have come in on meal and break periods again. So
yeah, okay.
That might be something. Every year. So
maybe
that might be
that's
something you want
February.
to revisit. Yeah.
Yeah, maybe that's
be,
February.
Okay, then last question. If an employee declines to take a break or a meal period, are we required to pay the penalty, regardless if the employer did not prohibit the employee from taking their break and meal periods? So the employer wants them to take a break, they chose not to. Do they have to pay the penalty?
Yeah, that's the age-old question, right? Okay, Kurtis, we can throw out different answers here because, again, how conservative and how aggressive do you want to be? I know what Kurtis is going to say. Go ahead, Kurtis.
Well, it's also going to depend if we're talking about rest breaks or meal breaks.
Yeah.
If it's a meal break, it's strict compliance. It either happened or it didn't. For rest breaks, we'd have to have a whole discussion of the, oh my gosh, the name of the case is escaping me at the moment. Brinker. We'd have to have a Brinker analysis, but it's just going to depend. We need more facts. We need more detail to be able to answer that question.
Yeah, I will just say this, every time this happens and every single client of ours complains about it, every time I ask an attorney, and I have polled several, they all say the same thing: pay the penalty, write up the employee if that's what you need to do. Right now, I will say, like, when we write a handbook, we have it in big, bold, italicized, underlined words that basically says, hey, you're afforded your meal period and your breaks, and if if you have any trouble taking them, you need to go to your manager immediately and say so. And if you fail to do that and you fail to take it, we're going to assume basically you chose not to, right? Having said that, it's rarely enforced that way. We rarely say, nope, not going to do it. Some attorneys will say, have them sign something acknowledging that it was on them, they chose not to. That's a more aggressive approach and just one that you should proceed with caution on.
Okay, with that, then we just want to thank everybody for attending today. We know you're busy and we appreciate you spending some time with us. Linda, Kurtis, appreciate your time today. Is there anything else you want to add before we wrap it up?
Nope. Thanks to you and Kurtis, and thanks to everybody for attending. And your slide handout was accurate, and I apologize that the slides I'm showing you do not match, but for the most part they do. So if you have any follow-up questions, feel free to reach out to either one of us. If you have any suggestions on future webinar topics, always let me know. We'll make a note of the meal and break periods and go over that again. And then again, sign up for the January 19th webinar on the Pay Transparency Act. All right. Thanks so much.
Have a great day.